Hello, everyone, and welcome to our 10th webinar. We are happy to have you here with us. And as with all of our past webinars, this is a strictly informational webinar and is not legal advice or a substitute for legal review. In order to receive legal advice on your particular matter, you will need to have an attorney review the facts and laws and then advise you based on your specific issues. Holmquist & Gardner is a law firm of dedicated, successful, and effective attorneys explicitly focused on our clients' needs. We are results-based and provide ethical professional counsel in the practice areas of litigation, business, employment, real estate, and construction. Holmquist & Gardner is a law firm of experienced professionals focused on providing effective legal counsel in a time and cost-effective manner. We value every client relationship and ensure that your every matter or issue receives the utmost attention. We recognize that your time is important and responsiveness is critical, and we act accordingly. And now I'm going to pass it over to one of our managing partners and the host of this month's webinar, Imants Holmquist.
Thank you, Jackie. Appreciate the warm introduction. Thank you, everyone, for joining us today. Very excited to have our newest associate, Joe Cobb, with me today to talk about LLCs. And Joe hails from Arizona and went to the better Arizona Law School, as he says, Arizona State University. Joe came to us from another local law firm after moving up here from Arizona. We're really excited to have him. He's been a great addition to our transactions team. Today, we are going to talk about entities in a general business sense and also get into some real estate issues. Three main kind of topics: the differences between entities, corporations, LLCs, PLLCs, and PSCs, issues with formation of entities, and then key issues for real estate entities. It's pretty high level. Going to take maybe 20 minutes, maybe less, try and fly through some stuff, get some high level insight, and then open up to questions so that you can get some answers. Again, this is informative, not intended to be legal advice. And with all these issues, we're going to say repeatedly here, your best, or not best, but one of the key pieces of the puzzle is your CPA. We had a great CPA on a couple webinars back, Harold Spear, and we recommend that you consult with them as well before making any decisions on these matters. So with that, also we've got in the background, Mike is our PR guy. You may have seen emails from him, and Mike will be helping us move slides along. So if you hear us talking to him, thanks for your help, Mike. Now I'll let Joe take it away for the first part of this. Thanks, Joe.
Thanks, Imants. All right, so I get the easier part. I'm going to start with kind of the skin deep level issues, and then Imants is going to dive into something a little bit tougher. So we're going to start off with talking about the differences between the common types of entities. You've probably heard of most of these, if not all of them, but you've got your single member LLC or your sole proprietorship, an LLC with one person, a general partnership, a member managed or manager managed LLC usually has more than one person in it. And then you can appoint a manager to take care of your day-to-day business stuff, or you can keep it in-house and manage it as member or assign another member to manage it. You've got your C Corp, your S Corp, and then professional entities, PLLC and PSCs. A couple important notes on these is on the professional entities, in most circumstances, every member has to be licensed in that profession. So they're profession specific, and there's a stricter set of rules governing the professional entities. So let's go ahead and move on and talk about forming an LLC. So an LLC, or at least the formation of three parts: the certificate of formation, which is what we send to the Secretary of State. And this usually has addresses, email addresses, and the basic details of the business. Then the operating agreement, that's the rules that an LLC will abide by. One note is that an operating agreement is not actually required in the state of Washington. If you don't have an operating agreement, there's a statute on point that will govern and set out some basic rules for your LLC. We always recommend an operating agreement. And a few reasons for that is the benefit of an LLC is you get flexibility. And with an operating agreement, you can draft the management and the rules of your company and your business to meet your needs. And if you don't have an operating agreement, the default rules aren't flexible. And so it's always best to just set the parameters and get that operating agreement out there. And then the third part is if you need a bank account or you want to hire employees, you need to obtain an EIN from the IRS. All right, Mike. And then forming a corporation is a little bit trickier. So an LLC, we always talk about how easy it is to form. It really isn't too tough. A corporation can be hard. You have to start with your articles of incorporation. It's that same basic contact information, business addresses, phone numbers, emails, those sorts of things. And then you've got corporate bylaws. I like to think of corporate bylaws as the rules that the company abides by. And the shareholders agreement, which is the second or third part, I like to think of as the rules that the actual shareholders abide by. And so you've got two separate documents that create rules for the corporation. One of the benefits of a corporation is the board of directors. It's a very well-known, it's a known commodity as far as internal roles and structures go in a company. And those are set about in the shareholder agreement. It's where you appoint people. And then the bylaws is basically where you dictate what people can and cannot do within the company. In a corporation, you have to actually issue shares of stock. And before getting a bank account and doing any real hiring, you need to obtain an EIN from the IRS, same as the LLC. Mike, thanks. So let's talk really quickly, and we're moving as fast as we can through this, so Imants can have some time at the end to talk about real estate issues. Let's talk about an LLC versus a corporation, kind of the pros and cons of each, because one of the main questions we get from clients is, what kind of entity should I look into starting? The pros of an LLC, we touched on this already, is flexibility and they're customizable. If you have something special that you want to do, or you have some ownership arrangement or what be it, and you're thinking, I don't know how I get that to happen, you probably want an LLC. The LLC just allows more leeway and more flexibility. There's less case law restricting how you can set up an LLC and how you can structure an LLC as compared to a corporation. LLCs have easier upkeep and maintenance. Once a year, you have to renew your LLC. It's a really quick, easy annual statement. And to pass resolutions and consents really isn't that tricky. LLCs are pretty easy to manage. And one of the benefits is it may be, an LLC may be, but isn't always, a pass-through entity for taxation purposes. And what this means is that the taxes pass through the LLC to the members, and the members report the taxable income on their personal tax statements. The pros of a corporation are pretty simple. Venture capital firms and investment firms prefer corporations. A lot of times these VCs won't even look at an LLC. So if you have a company and you're thinking, hey, pretty soon I'm going to want to get some VC money and I'm going to want to scale this, you may want to look into getting a corporation. The board of directors, which exists within the corporations, is a known commodity, as we said before. And even organizations like banks sometimes prefer to work with a corporation, and it's easier to work with a board of directors than it is with an LLC, because in an LLC, the roles that can be assigned to certain members can be changed and tweaked. And so they have to go back to the operating agreement to see, who has the ability to take out a loan on behalf of this company. And then this can be either a pro or a con, is that corporations are taxed separately from the individuals. So you'll have to consult with your CPA on that one, but in the right circumstances, it could be a benefit. Mike? So for an LLC versus an S Corp, this is another one of the most common two entities that we have compared against each other. I've heard an S Corp called a small corporation, but the S actually stands for the section of the tax code that is based off of, but it kind of fits. You can think of an S Corp as a smaller, scaled down corporation. So LLCs and S Corps have a few things in common. The first is you've got that same limited liability protection. Both of these companies exist to protect the owner. And so you can kind of look to either of them to get that same benefit in most circumstances. And they may both be pass-through taxation entities. So no income taxes are paid at a business level. The profits and loss pass right through to the owner's personal tax returns. Some of the pros of an LLC is that you've got multiple units or shares of ownership that can be created. You could have, Class A units, Class B, Class C, and you can assign different interests to each one. You can have an unlimited amount of members in an LLC, and non-US citizens and residents can be members. An LLC can be owned by a corporation, another LLC, a partnership or a trust, and you can create multiple layers of businesses to protect your interests and to kind of separate certain facets of your business. You can have subsidiaries in an LLC, and then you have that flexibility to change and adapt. A lot of times we'll draft a simple LLC for someone who needs a business, and then a few years later they'll call us and say, hey, I want to take on partners, or I want to change the nature of my business and I want to start investing in real estate or what have it. With an LLC, they're pretty simple changes to make, and it's easy to do things like bring on new members and bring on a new partner. And then the last pro, and we've said this a few times, you just have less upkeep with LLCs. They're easier to take care of and they're easier to keep running. Some of the cons of an LLC is it's hard to convert an LLC into a corporation. And as I said before, venture capital firms, investment firms, they don't typically invest in LLCs. They'll say, hey, if you want our money, go convert into a corporation. And that can be tough. It's not as easy as we want it to be. So if you know ahead of time that that's the goal, you may want to consider an S Corp. Some of the pros of an S Corp is it's easier to convert into a C Corp. You get some of that same pass-through taxation benefit you get in an LLC, and you've got the board of directors structure, which is widely understood. The cons of an S Corp are, well, they can be substantial to a lot of businesses. You have a limit of 100 shareholders. A lot of people think they'll never have 100 shareholders. If it doesn't matter to you, it doesn't matter to you, but it can be a limitation. Another limitation is you can only have one class of shares or one class of ownership. So you can't do a Class A shares for people who invested in round 1 and Class B for people who invested in round 2. You can only have Class A. An S Corp cannot be owned by a corporation, LLC, or a partnership or a trust. So it's kind of the end of the line as far as your layers go. And for some people, this will matter than others, but only US citizens and US residents can be shareholders in an S Corp. And I'm going to hand this over to Imants to take us through a deeper dive into key issues with real estate entities.
Thank you, Joe. Appreciate it. And I think a couple high-level things before we even get into these issues that we've got up here on the board. I would just say one of the key, there's kind of two main reasons you start entities. One is limited liability protection for the individuals. You're thinking you're going to start a business. You don't want to have your primary residence sought after for a judgment that exceeds the assets of the entity. So you're trying to protect the members' personal property and personal assets, or separate the liability between different assets. And we'll talk a little bit about that. If you're going to do that, you need to keep the entity, one, formed properly with the Secretary of State, and you need to follow the formalities that the state has set out to keep those entities moving forward and alive and well. That means complying with your own operating agreement, bylaws, shareholder agreements, less shareholder agreements, but the actual operating documents, regardless of whether it's an LLC or corporation. Another thing you need to not do is commingle funds. These entities need to be treated as their purposeful entities and not as a business that is your student's college fund, your kid's daycare payment facility or whatever, and also running this real property. You need to have separate bank accounts, and they needed to be treated separately. Otherwise, when somebody sues you, lo and behold, they will say, look, you're not even treating this entity as a separate entity. We're going to pierce the veil and you're going to be personally liable. So one of the things we like to do when we look at these entities is kind of an annual sort of review to look at it, make sure that if there were any changes that happened through the course of any given year, we document those, and the operating documents all say that any corporate resolutions or LLC resolutions are made. And then it goes without saying, we don't commit fraud. If you commit fraud or do anything like that, no entity is going to protect you. So you can't really hide behind that limited liability shield if you're going to buy a Ferrari and use the LLC for funding, and the LLC has no money. It's just completely undercapitalized. So getting on to some key issues that we hear from clients from time to time. Whether and when to transfer property into an LLC. Very common question is I've got a single family residence or 2 or 3, and I've been renting them out, and I'm wondering whether or not I should put them into an LLC or not. The first question we ask or tell our clients is to talk to their CPA. This is always a discussion about what are the tax impacts. You may have primary residence exemptions still available to you on those properties if you lived there for, I believe it's 2 out of the past 5 years. Again, can't give tax advice, but you may have some issue like that. Another issue that we talk about is whether or not the properties are financed or have deeds of trust securing the real property. So if you have a mortgage, all of your loan documents, I shouldn't say all, but none, let's say I have not seen any that do not have a due on sale clause. A due on sale clause says if you transfer the property to anyone, even an entity you own wholly, you are the lender can call the note due and payable in full immediately and call you in default. That would obviously be bad on a $500,000 property, you know, and you get a letter from the bank saying you're in default because you transferred it to your own LLC. So there may be issues like that to consider. There's some question about whether you couldn't just quick claim it back to remedy that default, and obviously it's quite rare if you're actually making payments on that loan that a lender would call that due, but it's something to consider and talk about. Which entity type? Again, for real estate, almost always it's going to be an LLC because of, as Joe mentioned, the flexibility that's there. Typically, there's multiple members. Typically, there are waterfall provisions we'll get into. And so the LLC is almost always the case. Now, it may be an LLC, but the CPA says we're going to make it an S Corp because we've got employees. And for whatever other reasons, a CPA may advise you to start that. So almost always can be an LLC, but do check with the CPA first. A typical setup in the real estate world, and many of you may be familiar with this, is having a property management LLC that manages all the entities. Maybe that has employees. Maybe that has some brokerage relationships. And then each separate property is held in a separate LLC. Why do people do that? As I just mentioned, if you've got them each in their own entity and each property is actually treated as a separate entity and they have their own bank accounts and they have their own documentation, well, when you have a slip and fall on one of those properties and it exceeds your insurance limitations, they're only getting that property. The lawsuit will name that, assuming there's no fraud and assuming you've met the formalities in LLC, the members of that entity are not putting the rest of their assets at risk. So if you have a portfolio, those other properties stay separate. This is something that banks really care about. So you'll hear, and we'll jump around here and skip over to lending issues. They want to see almost always that you are a single purpose entity. Now there are single purpose entity provisions that go into that. Many banks have their preferential terms that they like to see, or their counsel will say, these are the terms we would like to see. We'll literally review them, cut and paste them, and do an amendment to an operating agreement. Why do they want to see a single purpose entity? Because they don't want any previous liability or issues with that entity having crept into the sort of chain of liability in a way that might detrimentally impact the creditworthiness of that LLC, among other reasons. They may make you form a whole new entity. They may let you sign an affidavit that says that you haven't done anything else, or to the extent you had a previous project, it's long been sold. Most of the time, they're going to make you just start a new entity. If you start a new entity and you didn't have these SP provisions, then you go through those, review them, and work with the lender to make that happen. Another thing you might see is that if the loan's big enough and it's an East Coast lender, they will require that you either start a new entity and transfer into a Delaware entity instead of Washington, or that you convert. And there is a conversion process, and it's pretty simple. But this all adds a little bit of expense because sometimes you're going to need Delaware counsel to walk you through an opinion. Why do they want that? Delaware has the most case law on LLCs. So they have the most case law on corporations as well. That's why people use Delaware entities, or that's why banks require them. And their theory there is, well, if we can just know that this operating agreement is going to be great in Delaware because we've done so many of them, why would we try to learn or have our attorneys learn all of the other 49 states' random LLC laws? So that's what they're asking. Don't be too surprised when that comes up. Management powers, we spend a lot of time allocating and sort of differentiating from stock forms for management powers in real estate entities because you're going to have a wide array. Sometimes, as we'll get into with a development plan or budget, you will have a very well known and laid out set of parameters in terms of a pro forma and what's going to happen with the property. And you will say, hey, manager, you're just going to go. And these are, once we agree to these things, you have all the power in the world to execute those documents and the authority to do all of that. Other times you'll say, well, we really just, don't know yet, but we've got this entity, we're going to acquire assets, and we'd like to circle back and check in with this manager before giving them sort of anything beyond day-to-day functionality. Limitations on management include everything from some dollar amount that they're not authorized to spend or encumber the LLC for in terms of debt, the ability to sell or lease property, the ability to hire a broker or use a certain broker. You want to have those well defined. With real estate entities, if the concept is that you are going to be developing a piece of property, if I'm representing members, I typically am trying to figure out how well defined the development plan is and have a budget and have those agreed upon in advance, particularly minority holders in entities that aren't going to have a lot of power. We do a lot of reviews for private placement memorandums that other people put together. We're not typically doing securities work. That's not something we hold ourselves out as doing. But we do review these, and what we like to see is that there's been a pretty fair plan laid out. And so, yeah, you're buying in, and yeah, you're a minority interest holder with very limited control, but there's a pretty good plan laid out that everyone's approved. A couple other issues: waterfall provisions are really big. This is really where all the money's going to go. And this is a key point of emphasis in real estate entities where there are multiple members and different structures for how people are going to get paid. This includes having brokers have certain percentages or take at the end, having preferred rates of return, or figuring out ways to have commissions paid out in a different structure. Finally, a big piece of what we talk about are competition provisions. LLC members have duties of loyalty to one another. Managers as well, a duty of loyalty and a duty of care. Same with shareholders in a corporation. One of the duty of loyalty is basically a duty not to take business opportunities that come to the LLC from the other members, right? We all invested our money together in a corporate context. We're all shareholders together to sell these widgets. If you find a better way to make widgets, I expect that you aren't going to take that way to go make more profit or start another company to compete with us. Well, in the real estate context, most people, not all, but most are going to say, well, I'm going to operate in the Seattle area and I'm going to do, office buildings. Well, okay, if you're going to do multiple office buildings with different ownership structures, then you should put in the operating agreement that, hey, everyone knows that Jim Smith, our manager, owns multiple buildings and, is not going to have any duty to tell us about that. Or if the expectation of the members is that there is going to be a non-competition clause, this is where you would spell that out so that it's clear. Most of the time, again, we see some disclosure that there are going to be some competing interests there, and those aren't going to be a breach of the duty of loyalty. All right, with that, I will open it up to questions. And so if you've got a question, go ahead and type it into the chat. And our first question is from one of our favorite guys. And
I got this one, Imants.
I'll say his name because he's awesome. I won't tell everyone, I won't say other people's names, but we've had Derek Hermson on as a guest, and he's asked about the best way to form a purchasing entity for vacation rental in Mexico in terms of both liability protection and tax considerations. And I'll let Joe handle this since he has some experience in that.
Yeah, so we cannot advise you on the best structure that you'd want to take for that, but you can use a notario público or a public notary in Mexico. They're the only people with law degrees who are authorized to do real estate deeds and things like that. And they'll be able to help you set up a structure that'll help protect your vacation rental in Mexico. Yeah.
We had another question about, well, I liked your answer there, Joe, but I will say that these do typically go into trusts in Mexico, if I'm not mistaken. You hire an attorney, they set up a trust due to all the rules surrounding how real estate's held, and that's a constantly changing thing, right, Joe?
Yep, constantly.
So you hire counsel in Mexico, and that'll be the best answer there. We had another question about applying for an EIN, and it seems like it's taken some time. The EIN process is one that we like to have a CPA accomplish because although it only takes like about 30 seconds to go on to the IRS website, there are a number of sort of scam websites out there. So you need to make sure that you're on the IRS website for forming a new entity and getting an EIN. There's also a few boxes you need to check, not least of which how you're going to be taxed. So since we don't give tax advice, we don't fill that out. That's something you should have your CPA do. If you have done it and you went online and you did not get a result in like 10 seconds, then you did something wrong, because those get issued very quickly. You get an email response within a few minutes or hours, if memory serves, and they send you an EIN letter saying this is your EIN. Thank you very much, and we look forward to seeing your taxes. So if you're having trouble with that, work with the CPA to get that going. It is pretty easy to Google, but again, there's a lot of sites out there that want to charge you money. This doesn't cost anything. So, and then if you get your UBI and you're going to have employees, again, you want to work with your CPA to register as a business in the state of Washington, and then any cities that require that, like the city of Seattle has a business licensing program as well. All of this is available online. Both of those have different boxes you need to check with your CPA. So I have a number of questions here on series LLCs and whether they're allowed in Washington state. And I have to say that I have not dealt with series LLCs. Joe, have you had any experience with series LLCs?
No, I haven't.
I think the concept is that you draft a similar LLC and they're repeated. I can't speak to whether they're allowed in Washington state. If you have questions about that, we will review that and be in touch. But I do hear another commenter saying series LLCs are not supported in Washington. So
yeah, I didn't think they had been. I've seen it in other states, but I've never seen a series LLC in Washington.
Okay, great. I had another question. Can you go over member managed versus manager managed LLCs? Joe, you want to spearhead that one?
Absolutely. So in a member managed LLC, you appoint one or more of the members, and that's the owners of the LLC, to manage and take care of some of the day-to-day businesses. When you appoint a member or multiple members to be managers, you give them certain powers within the LLC. They can hire and fire employees. Occasionally, you can grant them extra powers like securing a loan or dealing with tenants, evictions, signing new lease agreements. You can kind of give your manager whatever power you want them to have in an LLC, or you can restrict it. So a manager managed LLC is one where the members appoint someone who's not a member to be the manager. Usually that person is paid and they take care of more of the day-to-day business things.
Yeah, I'll add to that by you could have a member managed that is a manager, or you could just have members that are voting on all the issues and there isn't a day-to-day manager. And so there's a lot of, and then we've also done ones where you have a committee of managers. This gets to the flexibility of LLCs. You might say it's sort of the three sort of founders or people that are going to be operating the property, that those are going to be a management committee. We sometimes have sort of larger investors that are going to be on this like advisory board. And basically in those documents, in that kind of operating agreement, we're replicating a board of directors. It lends a little bit of stability to the entity, but it creates a little bit of drag because typically those managers will have even more restrictions, or they'll have to vote on certain things as a management body rather than just having one manager call the shots. You know, pluses and minuses between those are, and this is in a real estate setting, you know, you don't really want to be going back to all of the members to ask about, or you may not want to, if you own a strip mall or a commercial property with multiple units that are getting rented or leased, and they're multiple, and it seems like every month you've got a new lease to sign, you know, you want one manager to handle that. You don't need to go back to all the members to get authority to do each one of those. And so there's situations where you're going to have a manager. And this is distinguished between the manager of the entity versus a property manager. Some people are like, well, isn't that my property manager? And we sort of talk about that. Sounds the same, but they're two different. You know, maybe that your property manager is your manager. That wouldn't be extremely unusual, but or I guess it would be extremely unusual, but it's possible. It's all within the realm of possibilities. I would say that another issue that we see is single member entities. You know, there can be some different issues that arise in bankruptcy, and we have great bankruptcy counsel that we use, some inside the firm, some outside the firm, and there's certain issues that we talk about there that are just some additional things. And then looks like another question we have is that I have multiple vacation rentals in Hawaii. Older owner looking at using Washington LLC to also avoid Hawaii probate, also using an LLC to hold multiple rental LLCs. Yeah, you can layer these out, and there may be reasons to create entities here that are going to be foreign entities in other states because you like what's going to happen, the disposition of the assets. Estate planning is certainly, needs to incorporate a solid estate planning attorney is going to look at these entities and review those provisions for what's going to happen on death, and particularly with regard to guarantees and debt obligations that might be burdensome to the family, or that where the guarantor is older and may pass. We spend a lot of time in our lending documents trying to get automatic replacement guarantor language subject to certain conditions. Banks are typically going to leave that to their discretion. You're very seldom going to get, although we have gotten in the past, very strict transfer language where if certain conditions are met, then that guarantor will be deemed replaced, even though they've deceased. Now, with regard to using different states LLCs, I mean, really, where you die is a big part of what's going to impact your estate planning. I think really you'd really like to have your estate planning attorney, and if you're spending a lot of time in Hawaii, also look at whatever you're doing, and your estate planning attorney in Washington before you make a decision on exactly what type of entity to have. People talk a lot, this is a side note, about, well, I want to have a Nevada entity, and we do have someone asking a question about a Nevada entity. There's it seems like every couple of years, some new trendy state from which to have an LLC, and that's better for tax purposes. I've never been a part of that or seen any real benefit to that. So if you have a CPA that's got some cool way of getting you out of some taxes because you're using a different state's LLC, by all means, let us know. That's interesting. We did get asked, is an out-of-state LLC owning a property in Washington an issue for the purpose of liability? The answer is no, but you do need to register as a foreign limited liability in the state of Washington. That's a specific registration. You get a certificate of formation and you form, basically, it looks like you're forming a new entity, but what you're doing is registering. And the reason they want you to do that is because, again, this is a fictitious entity. It's not you. So how do I serve you? Well, there needs to be a registered agent in the state of Washington to be served. And likewise, if you're a Washington entity and you've got real property outside of the state, you should be registering as a foreign limited liability company in that state. You do risk some liability exposure if you are not doing that. And I'm not sure that I've seen case law on how that plays out, but you are not strictly following the formalities of that state's laws if you're operating a piece of property in their state and you are registered as a foreign entity, foreign corporation, foreign limited liability company. Okay, with that, I think that wraps us up. I want to thank you guys for coming. Thank you, Joe and Jackie and Mike, for helping us put this together. And reiterate, not legal advice. This is an informational webinar. We are very excited to have our next webinar March 25th, Thursday. Hamilton Gardner, my partner, one of our partners at Holmquist and Gardner, will be hosting that with guest Ben Dunwald of Merrill Lynch, and they'll be talking about business succession planning and issues with that come up in that regard. And there will be an email after this that gives you a survey. Please fill out the survey, and also the recap's available, and this is recorded. So if you have people in your office or friends or family that would be interested, please send the link that comes to you via email. We'd love to share that with them. Thank you again, and stay safe. Bye now.